We've all heard the song Rosa Parks by OutKast off their 1998 album Aquemini. But not all of us have heard about the lawsuit filed against them over the name of the song by the civil rights leader herself. Starting in 1999, Big Boi, Andre 3000, and their other co-defendants were embroiled in a nasty 6-year-long case in which they were accused of defamation and trademark infringement, though the lyrics never mentioned her or the civil rights movement at all. The suit was tossed out a few times, but her lawyers continued the never-ending battle, naming more defendants and requesting millions of dollars in damages. Then people grew suspicious about the whole thing once they found out that Ms. Parks was mentally impaired. So who was really behind all of these lawsuits? The recent copyright case against Ed Sheeran by the heirs of songwriter Ed Townsend has really had me thinking about all of the famous music cases over time. This is Parks v. LaFace Records, the forgotten 6-year dispute over a song. OutKast is a hip-hop duo from Atlanta, Georgia, made up of Andre 3000 and Big Boi, who rose to fame in the mid-90s with their experimental rap style that merged many music genres. Their first 2 albums were critically acclaimed, and by 1998, they were ready to release another successful full-length project. The album titled Aquemini debuted at number 2 on Billboard, selling 227,000 copies in its first week, and its second single, titled Rosa Parks, released on May 23, 1999, was a hit on urban radio and went on to become one of their most notable songs. The song even landed them a Grammy Award nomination for Best Rap Performance by a Duo or Group. On the Rosa Parks chorus, Big Boi urges rival rappers to move to the back of the bus. The title is a metaphor to the civil rights leader's refusal to give up her seat to a white writer and move to the back of the segregated bus back in 1955. Rosa was thrown in jail for her defiance, and the incident triggered a 381-day nationwide boycott of the bus system by African Americans. This led to the Supreme Court ruling the following year that segregation in transportation was unconstitutional, and public transportation became desegregated nationwide. She spent many years as an activist and continued to fight for racial equality, but Rosa retired from public duties in 1988 due to her declining health and age. About a week after the song's release, on Wednesday, March 31, 1999, Gregory J. Reed, Parks' attorney and co-author of her 2 books, Quiet Strength and Dear Mrs. Parks, filed a lawsuit on her behalf against the duo and LaFace Records, its parent company Arista, and distributor BMG Entertainment, in a Michigan federal court, claiming the group had illegally used her name without her permission under the Lanham Act and under the common law right of publicity. They also argued that the song both defamed her character and interfered with a previous business relationship. Back in 1995, Rosa Parks approved a gospel album called A Tribute to Rosa Parks, recorded by gospel artists including Yolanda Adams, Sounds of Blackness, and Shirley Caesar. The compilation album sold close to 1 million units. But her lawyers argued that she would have sold more if her name had not been included on the Aquemini album packaging, which they claimed led to people mistakenly buying the OutKast album, calling it false advertisement. They said Rosa felt exploited by OutKast and sought to halt sales of the record. They requested $25,000 in damages and to have her name removed from all of their products. Attorney Reed said, "You have her name associated with lyrics that contain vulgarity and profanity that she does not appreciate." Then Richard Manson, president of Millennial Entertainment Group that represented the civil rights leader, also told MTV News in a statement, "OutKast did not confer with Mrs. Parks about using her name or likeness in the song in question. She views this as the same kind of conduct that she faced 40 years ago, an abuse of people." End quote. But these claims were denied by LaFace Records general manager Dorsey James and OutKast, who responded with a statement that read, "Rosa Parks has inspired our music and our lives since we were children. The opportunity to use our music to help educate young people about the heroes in the African American community is one of the responsibilities we feel we have as music artists. It wasn't, nor has ever been, our intention to defame a woman who we consider a role model and a civil rights pioneer. We hope to be able to work out this situation amicably." End quote. To fight the case, Andre and Big Boy hired former Chief Justice of the Michigan Supreme Court Conrad L. Mallett to represent them. He issued the following statement: "Every United States citizen respects the profound contributions made by Mrs. Rosa Parks. The two young men who make up the group OutKast have conveyed to me their deep dismay that representatives of Ms. Parks have somehow convinced her that their release of the track Rosa Parks and that OutKast has commercially exploited her name. They wish to convey to Mrs. Parks their sorrow for any misunderstanding and want Mrs. Parks to know that they would never seek to take advantage of one of this country's genuine heroes. OutKast is shocked that representatives of Mrs. Parks would sue them knowing full well that their honorable use of Mrs. Parks' name is protected artistic expression designed to pay homage to a great human being. They regret that this issue has degenerated into a legal contest, but are confident that the respectful use of her name in the title of the song was and is appropriate. Everyone in this country loves Mrs. Parks, and quite frankly remembers all of the years she worked for Congressman John Conyers Jr. as an assistant and office manager. Mrs. Parks and I were on the congressman's staff at the same time. I can assure you that I would not have taken this case unless I was sure that Millennium's position on this issue was dead wrong. My clients have a First Amendment right to express themselves, and Mrs. Parks' lawyer know full well that these young men were absolutely allowed to use Mrs. Parks' name in their song. The attempt to separate the protected song from the CD cover is legally and metaphysically impossible. The United States Supreme Court has stated it is clear that speech does not lose its First Amendment protection because money is spent to protect it." End quote. The right of publicity is a property right that protects the name, voice, signature, photographs, and likeness of a person from commercial use without consent. This right is usually associated with celebrities since their name and image are often used to sell products or services. Oral arguments were heard in court on November 4th that year, with Parks' team requesting a summary judgment against the defendants. But Rosa Parks, being a celebrated public figure, posed a conflict to her right to protect her name from the First Amendment right of others to use her name in an expressive work. So the case was dismissed by U.S. District Court Judge Barbara Hackett, who sided with OutKast by granting their motion for summary judgment, ruling that constitutional free speech rights under the First Amendment covered the use of her name in the song's title. So Big Boy and Andre 3000 were off the hook for now, but the battle would rage on for many more years. In late 2000, Rosa Parks and Gregory Reed enlisted high-power attorney Johnny Cochran to help her appeal the district court's decision, allowing OutKast to use her name as the title of their song. They took the case to a 3-judge panel of the 6th U.S. Circuit Court of Appeals. Arguments were heard in court on May 4, 2001, but the appeals court upheld the dismissal of the claims of defamation and interference with a business relationship, but reversed the decision of complete dismissal and reinstated the rest of the lawsuit, saying that OutKast needed to show some artistic reason for naming the song Rosa Parks. Lawyers for the duo expressed concern about what it could mean for the recording industry, saying in quote, "I think people in the music business and in the entertainment industry generally have to be worried about a case like this. The band believes the song is fully protected by the First Amendment and looks forward to winning the case again in the trial court." In 2003, their lawyer asked to be granted permission to interview Mrs. Parks to get an explanation of all of the emotional and mental distress she claims she suffered because of the song, and question her doctor about her medical condition. But that's when it was revealed that the 91-year-old was suffering from dementia and nearing the end of her life. OutKast petitioned the Supreme Court to dismiss the rest of the lawsuit, arguing that the song was not false advertisement and didn't violate her publicity rights as a historical figure. They went on to say that the appeals court unconstitutionally allowed public figures to use trademark and right of publicity laws to censor speech. But that petition was denied by the U.S. Supreme Court, which meant that Rosa and her legal team could move forward with their lawsuit in federal court and go to trial in Detroit. So they refiled the case in 2004, but this time, her legal team went after the recording companies and stores that sold the song and album, including Barnes & Noble and Borders, the music video director Gregory Dark, and the song's producer Braden Mendelson, requesting over $5 million in damages. But that's when the public and people related to Rosa Parks started becoming suspicious about the people surrounding her and the true intent behind the lawsuits. OutKast had become the biggest rap group in the world by 2004. They released 2 successful multi-platinum albums following the release of Aquemini, and Speaker Box, The Love Below had given them their biggest commercial success yet. They generally remained quiet about the lawsuit, but on the song I Can't Wait by singer Sleepy Brown, Andre makes reference to the suit without naming Rosa Parks.
Down, and yes, you're getting sued by women who didn't get up out they seat on the bus, and feet shouldn't rust.
The case started drawing criticism, with many people questioning the true motive, while the older generation accused the group of disrespecting the civil rights leader. Marjorie Hines, director of the Free Speech Expression Policy Project, told the Washington Post, in quote, "This case is not about her trying to prevent the unauthorized use of fame and good name to sell a product. She's trying to suppress a song and message that she considers offensive. She may be offended, she may be insulted, but the First Amendment really protects that," end quote. Rosa Parks' caretaker, Elaine Steele, was one of the individuals who filed the $5 million lawsuit on her behalf, and Rosa's attorney, Gregory Reed, said they plan to continue with 2 lawsuits against the group, seeking billions of dollars for allegedly exploiting her name. But this announcement drew backlash from Rosa's family, who says she was really being exploited by her handlers, Elaine and Gregory, who were only suing OutKast for their own monetary gain. Rosa's 13 nieces and nephews and other close relatives argued that she lived a very quiet, humble, and frugal life and would never sue anybody for something so small, especially while she's mentally impaired and in the final years of her life. Her name was also mentioned in other songs prior to the OutKast record, and she never requested money and damages. The family speculated that Rosa had no knowledge of the suit and probably never even heard the song, and they expressed these concerns with both Andre and Big Boy. Rosa's niece, Suzanne McCauley, said, "Auntie Rosa devoted her whole life to taking stands against the indignities and sufferings of her race. That is how she should be remembered, not as some money-grubbing old lady who sued a rock band. Auntie Rosa is a national treasure, but she is also an elderly woman who needs her family and whose last days should not be spent tied up in a lawsuit." Her other niece, Rhea McCauley, said, "I'm not a doctor, but I know, dementia or not, my auntie would never ever go to this length to hurt some young artist trying to make it in the world. As a family, our fear is that during her last days, Auntie Rosa will be surrounded by strangers trying to make money off her name." The family also collectively released a statement that read, "We believe our aunt would appreciate the fact that their artistic gesture was designed to keep her legacy alive and fresh in the mind of this generation and generations to come. These lawsuits are only about money, and Steele and Reed are trying to acquire it from OutKast." Years later, while looking back on Aquemini for its 12th anniversary, Big Boy and Andre opened up about the whole ordeal with journalist Rodney Carmichael. Big Boy said, "I took the beat home, and I remember I was in my room, and I was like, I got the hook. I was playing the music loud as hell, and I was just singing the hook. Like, that's it. We need to lay it down. So then, you know how we use these metaphors. So we named it Rosa Parks. Boom. We always do stuff like that, and just falls into place." Neil Polk, the sound engineer, said, "Naming that song Rosa Parks was a big statement too, because it was just trying to show people don't forget about where we've come from and where we are now. It was kind of weird because I think Rosa Parks was misled. She was misled by her handlers. They just wanted to get her some money out of it, and OutKast didn't mean any harm. It was a tribute, but her people felt like it was a slander." Producer Mr. DJ said, "We got a lot of flack about that. A lot of brothers got held up in lawsuits because of the song, but it was never meant to be a derogatory song towards Rosa Parks. That never even crossed our mind until we heard there was a complaint. We were just trying to use her as a symbol. Everybody moved to the back of the bus. It was just a real fact. We used to have to go to the back of the bus. It was just something real, and we try to make something positive out of it, not in a bad way." Andre 3000 said, "Their claim was we used her name to sell records, and we were like, that really wasn't the case. I think that was a huge confusion and misunderstanding. But when you're working with someone of Rosa Parks' standing, you've got to do your job. I understood it, but me and Big always said if something comes across our lap, we're gonna fight it. We've got enough money to do it." In late 2004, U.S. District Judge George Stee appointed former Detroit Mayor Dennis Archer to serve as Rosa's guardian to review all litigation files amid concerns of Elaine and Gregory exploiting her. Elaine was also fined $1,000 for failing to produce proper documents on behalf of the civil rights leader related to the case, and in early 2005, they were forced by the judge to release her medical records. Then a few months later, in April, the case against OutKast and their co-defendants was finally settled. Under the settlement, OutKast, Sony BMG Music Entertainment, Arista Records LLC, and LaFace Records agreed to work with the Rosa and Raymond Parks Institute for Self-Development to help develop educational programs to, quote, enlighten today's youth about the significant role Rosa Parks played in making America a better place for all races, according to a written statement. They would also produce and create a tribute CD along with an educational television program about Rosa Parks' life and legacy that would be distributed on DVDs to thousands of public schools nationwide. While Sony BMG's attorney, Josh Beck, said to the Associated Press that the defendants were happy with the outcome of the case, the settlement in the case did not necessarily mean that OutKast was at fault, and the public still questioned the real reason for the lawsuits. Rosa Parks passed away a few months later at the age of 92, but the lawsuit against OutKast impacted her legacy and brought her negative publicity in her final years. It actually did more harm to her legacy than the title of the song, and Gregory Reed was later prosecuted for selling her memorabilia and pocketing the money instead of donating them to museums. Months after her death, OutKast began working on a tribute LP to Rosa Parks and had an outline of a TV special in her honor. But that was the last we heard about the whole situation. I really want to continue to cover more big music lawsuits in history, so leave me some recommendations in the comments. Like this video and subscribe to BFTV for more content.